Hi, I'm William Bloodworth with the Bloodworth Law Firm. I'm often asked, how do I begin? How do I start a new divorce or child custody suit? I would like to discuss with you the 3 basic ways that you can begin a case. Number 1, you and your spouse or the other parent in a child custody case can sit down at a table and draw a line down the middle of a page. Put his on one side, hers on the other side, and then list what each of you are going to receive upon divorce. List what debts each of you are going to pay upon divorce. And if there are children involved, list which parent is going to have the children on a day-by-day basis and which parent is going to be awarded possession and access and visitation with those children. You will also want to include who is going to pay child support, which is most often the parent who is not in day-to-day care, custody, and control of the children. You will also want to provide for which party is going to provide medical insurance. You will also want to provide which party is going to have visitation and access in the summer and how long and for what periods. You will also want to determine what individual rights and duties each parent are going to have. For instance, which parent or both parents going to have the right and the duty to provide medical care and be able to consent to surgical and other invasive treatments of the children, and whether or not those rights are going to be contingent upon whether or not there is an emergency. These are the kinds of things that you want to include on this list. When you have finished compiling your list, you should each sign and date this document, and then bring that to the attorney that you have decided to hire to represent you, and that attorney can then take that agreement and utilize it in first filing your divorce and obtaining a court judgment or decree of divorce that is agreed. Now, there are other documents that you and your spouse will be required to sign along the way. Providing your attorney with a his and hers list signed by you and your spouse assures the attorney that his time and your money will not be wasted in drafting an agreed final decree of divorce only to have your spouse refuse to sign it. Please also take special care to list on the his and hers list things that you want to leave the marriage with, even if those same things are things you brought into the marriage and things which you believe your spouse should understand that they were yours before the marriage began. Number 2, the second way you can begin a divorce case is to file for divorce, have the opposing party served with a citation by the sheriff's deputy or constable notifying that spouse that you have filed for divorce. That spouse then has 20 days following service of the citation in which to file a written answer with the court. If that party does not file a written answer with the court or otherwise object to the proceedings, and you have had that person personally served with process, you may then go forward on your own with no further notice to that spouse of the divorce proceedings or any approval by that spouse of what is included in the court's final decree. If after being served with process, your spouse hires a lawyer, the case then becomes contested when that lawyer files an answer on behalf of your spouse. Just because a case is legally contested does not mean that there's all-out war. Oftentimes, reasonable attorneys who are professionals can often negotiate between the parties and obtain a settlement that is satisfactory to both parties, so that even though both parties have lawyers and it is legally a contested case, the case can be worked out by agreement and often concluded quicker and at less expense than contested cases which are indeed a battle. The third way you can begin a divorce or child custody case is not only have your spouse served with a copy of the divorce petition, but to also request from the court a temporary orders hearing and have your spouse or the parent of the children served with a notice to appear on a time and date certain for a temporary orders hearing. At that hearing, the court will obtain information from both parents or husband and wife, as the case may dictate, on the information the judge needs in order to make an initial temporary decision on which parent of the children should have temporary custody, care, and control of the children, and which parent on a temporary basis should pay child support and provide insurance benefits or coverage for the children. In a divorce case, the judge at a temporary orders hearing will make temporary orders as to which spouse should be awarded temporary possession and access to the marital residence, automobiles, or other property that one spouse or the other needs exclusive possession and control of. If your spouse is not voluntarily contributing money necessary to pay the joint bills and expenses of the household, or if they're not voluntarily contributing enough money sufficient to support the children and provide for medical insurance benefits, you need to request a temporary orders hearing. When you leave that hearing, the judge will have made an initial temporary decision and order which both of you must obey. Failure to obey the judge's temporary orders can result in the non-obeying party being held in contempt of court, fined, and even jailed for their refusal to obey a court order. Finally, there is one often missed benefit to having a temporary orders hearing. Oftentimes, at a temporary orders hearing, parties have the opportunity to settle their entire case. Think about it. The judge is there, each party is there, and therefore all the necessary elements are there, so that if you are able to negotiate with the other party an agreeable resolution to the case, you may go back into the courtroom and ask the judge's permission to hear your agreement, enter it on the record, take it under advisement, and when the appropriate statutory waiting periods in order to obtain a divorce have passed, the judge can then sign the final decree of divorce that's been prepared in the interim, and you can actually be divorced quicker and sooner than those persons who have started their divorce case by just filing for a divorce and then having the opposing party served and waiting to see what they do. The added benefit of requesting and attending a temporary orders hearing provides you with an opportunity to end your case early and to minimize the cost and expense of obtaining a divorce or a child custody order. I hope this information has been helpful to you. If you have additional questions, please don't hesitate to call us at the Bloodworth Law Firm. We're here to help you and would love the opportunity to talk with you about your unique situation.